Call this meeting of the Planning and Zoning Commission to order at 4:31. Dorothy, would you do a roll call, please?
Bob Waller.
Here.
Garrett Harmon.
Here.
Don Barnett.
Here.
Doyle Malone.
Here.
Bill Morgan.
Here.
Michael Siegerman. Rustin Zuber. Bonnie White. Here. Thank you.
All right, number one on the agenda for today's meeting, Visitors Citizens Forum. Any person with business not scheduled on the agenda is encouraged to briefly speak their ideas to the commission. Please fill out the speaker request form and give it to the commission secretary prior to the meeting. The number of speakers will be limited to the first 10 speakers, and each speaker is limited to 3 minutes. No formal action can be taken on these items, as the Open Meetings Act requires formal action items to be posted to an agenda no later than 72 hours before the meeting. If formal action is required, the items will be placed on an agenda for a future meeting. Number two, consent agenda. All items listed below in the consent agenda are considered routine or ministerial in nature and will be enacted with one motion. There will be no separate discussion of items unless a commissioner or citizen so requests, in which case the item or items will be removed from the consent agenda and considered separately. Item 2A is approval of the minutes from the February 25th, 2016 meeting, and it's on page 3 of your packet.
I'll make a motion to accept the minutes as presented.
I'll second.
There needs to be one change.
Okay.
On item number 1, it's minor, it says call to order. Commissioner Waltler called the meeting to order. It was actually Commissioner Harmon who called that meeting to order.
Any other amendments to the minutes of the February 25th meeting? If not, I have a motion and a second. All in favor, aye.
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 All opposed, same sign. Thank you. Passes 5-0. Number 3 is public hearings and action. Number 3A, public hearing and action and zoning. Public hearing consideration and action concerning a requested amendment or amendments to an existing plan development district, PDD.
Excuse me, Bob, there's
Yes.
a 2B.
Oh, excuse me, let me back up. There was a second set of minutes. 2B, approval of the minutes from the March 3rd, 2016 meeting on page 5.
And I have a change. I was absent.
Okay. Okay, I'll accept a motion on the minutes of March 3rd, 2016.
I move that it's approved with the change that Commissioner Malone was absent.
A
Second.
Second.
I have a motion and a second. All in favor, aye.
Aye.
All opposed, same sign. Thank you. Thanks, Doyle.
Sure.
Number 3A, public hearing and action, zoning. Public hearing consideration and action concerning a requested amendment or amendments to an existing plan development district, PDD 01-23. Ordinance number 2001-23, section 3A through R, for an approximate 75.73 acres tract, being all of a certain tract or parcel of land containing 75.73 acres, more or less, out of the O.V. Robinson Survey, number 44, abstract number 282 in Kerr County, Texas. Trent, can you
Yes,
bring us to speed?
thank you, Mr. Waller. The request is to amend the existing Plan Development District PDD 01-23 ordinance number 2001-23, section 3, letters A through R for an approximate 75.73 acre tract. This property is known as the Airport Commerce Park. The staff did mail out 17 notices to property owners within 200 feet. We didn't receive anything in writing from anyone in opposition or in favor. We did receive a phone call from a gentleman who was opposed and had some concerns about the proposed amendments. The subject property is relatively flat with a few trees and various types of grasses. It's really, since this ordinance was adopted back in 2001, there hasn't been too much development on the lot. And due to that is the restrictions in the development regulations and the types of land uses permitted by right. On November 27, 2001, City Council approved the existing PDDs, and over the years, the property has been marketed for development with little to no success. The existing planned development district has various design, development, and land use regulations, in addition to all existing city codes and requirements that have made it difficult to develop. The proposed amendments to the existing planned development district will broaden the permitted land uses and eliminate various development regulations. In your packet, you'll see the land use table of the uses that were permitted in this ordinance prior to the amendments that we're recommending today. Then I believe there's a list of 67 that were very specific in nature. Staff has narrowed that down and referenced the changes are referenced more towards the E26 zoning district, as shown in your staff report as well. That's what it allowed the uses to be a little bit more broad and be able to make the property more marketable. We also did eliminate some of the phasing requirements and development regulations and made it more in line with city regulations with the city zoning code and subdivision ordinance. As I said before, the property is relatively flat. Right now there's some development out there, but it's mostly undeveloped right now. Across the street is the surrounding land uses is the Kerrville Airport, as well as next door is the Fox Tank Company. These images are showing you what's
Well,
currently
Fox
around
Tank is using one of the buildings on that property.
The Fox Tank building, I believe they are using one of the buildings, but it looked like the majority of their processor company was using properties adjacent to the planned development district right now.
What was the objection of the person who called? What was their objection?
They had, it was the original owner of the property, of the Airport Commerce Park. He's the one that brought the planned development district to fruition back in 2001. He said he might be showing up today, but some of his oppositions were, he thought the regulations set in forth, the development regulations should stay in place, such as the screening requirements, when certain phases should take place, and how the land use table was created, keeping those specific uses very specific instead of being more broad, as in our zoning district shows today.
So the benefits would be that we'd have more latitude
Yes, sir.
to develop this land under different conditions.
Right. It would allow the property to be easier to develop as in any other property within the city limits. Allow the uses to be more broad, but still have limitations on those uses. There are still some regulations still in place, such as there are still some screening regulations. Access to the lot, there's no direct access from Highway 27 to each lot. They have to have their own separate access from a road inside the lot. So there are still some limitations, but there's definitely quite
There is a
few of them
road
that
that
are
goes
for
in there, though.
What was that?
There is a road that goes in there,
Yes,
into that
and-
property, in the middle of that
Right,
property.
and from that road, they don't have any direct access to Highway 27. Staff does recommend approval of the amendment, and we go ahead and ask you to hold the required public hearing and make a recommendation, council.
Okay, I'm gonna open the public hearing at 4:40. Anybody wishing to address this commission, please move to the podium and state your name and address, please. Okay, seeing none, I close the public hearing at 4:41 and open this up to discussion amongst the commissioners. I would like to make some comments. I've done a little study of this and actually talking with the prior owner. I have some concerns. Some of these may be addressed in the amendments. There was a plan development agreement that talked about how to handle the different phasing of the property. And my understanding is when one phase was 75% completed, that it required the owner to go ahead and put in place infrastructure for the second phase, and et cetera, et cetera. And can you tell me, Trent, if that's amended in the proposed amendment?
The development agreement that's come about, once again, we just want to remind the commissioners to keep in mind what their responsibility is to focus on the zoning of this. But the development agreement, they did take out, some of the amendments were part of the phasing and how kind of what requirement, the timeline of the contract of the development agreement was extended in order to allow them more time to pay back any fees to the city that were agreed to by EIC and City Council and the current or previous and current property owners.
What is the current payback to EIC for funds that were expended?
The existing, how much has been paid back, or the
What
total?
was the agreement as far as the requirement to repay?
I believe our city manager, Todd Parham, will go ahead and answer that question.
Yeah, the zoning is an exhibit to the development agreement, so y'all are really considering the zoning portion of that. So the questions that we're answering aren't part of the zoning, but there was $100,000 due payable back to the city through fees collected, and we have been collecting those fees as appropriate to the development agreement. But again, that's not party to what the role of the Planning and Zoning Commission is in considering what the zoning you have before you this afternoon.
Okay, thank you, Todd. My concern, irrespective of the fact that we're looking at the zoning is being proposed to be changed in order to expedite the sales of the property out there, to make it easier to sell and reduce restrictions that were part of the original plan development agreement. Is that correct?
Correct, yes, to make the property, the property has been marketed to sell, to try to develop. They've had some issues trying to develop the property due to the regulations that were set forth in the zoning ordinance. The developer came to us and see if they could get the zoning ordinance amended to make those more lax and be more concise with what every other property in the city is required to do.
Okay, my concerns really are two. Number one, the relaxation of requirements, I think, could produce businesses that are really not conducive to the original structure of that airport commerce park, and could really go against what I'm come to learn of the quality standards of the city. That's one of my concerns. The other concern is that you've got two businesses, Fox Tank being one. TxDOT bought about 7 or 8 acres out there, and they bought their property based on those restrictions. So my concern is, if you change this property zoning to ease these restrictions and open it up more across the board to a broader array of businesses, that you could have some, or the city could have some potential liability from people that own the property currently, their respective tracts. Any comment, other comments?
I concur with what you're saying. I don't think it would be fair to the ones that built under previous conditions now to change the conditions with less restriction. They've made it a monetary investment based on the original restrictions. And I don't see the need to change these to accommodate the sale, because it would not be, it would be detrimental to the zoning requirements that the others had to live with.
Trent, did TxDOT file a complaint?
Once again, we didn't receive any complaints from anyone besides that one phone call we received. And we did send out notices as required by state law to all property owners within 200 feet, posted in the newspaper, put it on our website as mandated by state requirements, and we did not hear anything back from anyone.
Now, going through the proposed land uses for zoning E26, it seemed pretty reasonable to me. I mean, I didn't see anything in those lists of permitted or not permitted uses that stood out as a conflict. While I respect the agreement that the previous landowners or the landowners out there entered into that property with, I also think that getting some congruency between old regulations and new regulations is desirable, trying to get everybody under the same rules. So personally, I think the E26 seems like a fair zoning requirement.
Well, what is the most significant difference in the two zoning?
The most significant difference between the two zoning districts is our E26 zoning districts allows for some interpretation for uses when they change over time. It also allows for a facility out there to do training, a vocational training.
Which was not allowed before.
Right. With how the planned development district land uses were designed previously in the current ordinance, it was very specific. Anything outside of those allowed uses was not permitted unless they came in and amended the planned development district. Under the E26 zoning district, as adopted in this, as proposed in this draft ordinance and in the staff report, there's certain, in our zoning code allows for certain uses under personal services, retail trade, to allow more flexibility with what uses are allowed there. There are still restrictions. They have taken out certain uses that were allowed in the E26 zoning district. Multifamily is not allowed. If this is adopted, multifamily would not be allowed in the zoning district, or for this planned development district. So they did go ahead and still take out some uses.
Well, what I saw in comparing the two lists, the one that relates to District 26E zoning and what you propose here, you've added building construction, general.
Yes.
You've removed multifamily.
Yes.
You've added education, secondary and college. I guess the training you were talking about.
Yes, sir.
You removed primary education, but you added one that I didn't really understand: vehicle sales or service used.
Right. So under E26 zoning district, as permitted by right, you could sell new cars there, and you could do work on new cars there, but you couldn't have any used sales there of any car. And so we went ahead and added a used car lot, as well as allowing the service of used cars to be allowed on that site.
And you feel that's conducive with what an airport commerce park should offer?
Well, if we're going to allow new car sales there and service on new cars, yes, I think that is conducive. The two uses are going to be, especially with the other uses that are permitted in the zoning district, such as the vocational training, some of the business trades. I mean, you have Fox Tank right next door. That was not originally in the planned development district, and you have the airport across the street. I don't see that would be detrimental to the area.
Okay, thank you. Any other comments from the commissioners? If not, I'll accept a motion.
I move that we approve the zoning change to E26 zoning as presented.
We're just to re-clarify, we're not changing, we're amending the planned development district, as stated in the staff report, to minimize the land use regulations as well as the uses permitted. So you'll need to make sure your motion states that we're actually not changing the base zoning
Okay.
district
Just
E26.
Let me
add
ask you,
E26.
one other, the changes that you make there, would they also then apply to the planned development, next door, the tan one, where Fox Tank and all that is?
Once again, the majority of Fox Tank, I believe, was built before the planned development district, but it's also not located inside the planned development district. I think they own one lot inside it. They're not utilizing it as the planned development district was intended for.
What I'm asking is, the rules we're making now, are they gonna apply to the other area that was built?
Right, for the full 75 acre tract, sir, yes.
E26 is 75 acres, all right?
Once again, it's the amending of the planned development district. The boundaries are not changing as we're back in 2001.
But the PDD, which is across the road or whatever there, those rules are gonna apply to them too,
Right, it will apply to the whole tract.
to the whole tract?
Yes, sir.
But not to the piece that Fox Tank is at that is currently zoned E26. That will remain E26.
It will remain
Yeah,
E26.
where Fox Tank has about 25 acres, zoned E26, that is unaffected by this
Yeah.
action.
Martin, could you please pull up the PowerPoint
E26 is right
for
here.
the zoning?
I see that, but what,
That's where Fox is.
But
Most of Fox is right there.
but is
Like,
this?
could you pull up the
these
aerials,
there's
are
a
built-
the
there's a
aerials on it
box
from
in
the
there.
previous
Right,
presentation?
that's what I'm saying, are the rules here gonna apply there?
Just 1 second, sir. So everywhere if you look on your screen, everywhere in that 10 area is the area proposed to have the amendments made. The zoning district will still be a planned development district, but with the uses permitted as in your staff report is stated and the draft ordinance in front of you. That purple section that says E26 where Fox Tank is located at, where the majority of their business is located at, their primary structure is located at, will stay at E26. That is not being zoned. It's just the area highlighted in red, the solid
Okay,
red
just
line.
inside the red loop,
The red solid line, not the red dashed line.
okay.
But the Fox Tank facility inside of the.
If it's within that, yes, if it's within that red solid
What's
line.
the impact on Fox in their grandfathered?
I don't think there'll be any
There's no
property.
impact on them. They have a very minimal operation in there now.
Right, I mean, just as Texas state law, I mean, this won't have any impact on them. They'll be able to continue on with their business. But this won't have any.
I'm not sure that
impact
they
on
own
them.
that building. I think they rent it. Yeah, I didn't think they owned it. so.
So we're not changing the zoning, we're just amending
The planned development
the
district.
planned development district.
Yes,
Okay.
sir.
To give it more latitude.
Okay,
Okay.
Garrett made a motion, I will second.
Let me restate the motion. I move that we approve the amended ordinance of the planned development district to include the land uses in E26.
Yeah, you could, I mean, yes, you can make your motion that way, or you can, as stated by staff. Also, keep in mind the development regulations. And I also shared with each one of you the proposed draft ordinance that should be in front of you, showing all the development regulations that will be as part of the what we're proposing as the new planned development district. If that helps you with any sort of motion.
Okay, I'll try again. I move that we approve the amendment to the planned development district as presented by staff.
I'll second.
I have a motion and a second. All in favor, raise your right hand. It passes 4-1. Okay, the next thing on the agenda is 3B, and I, as chairman, have turned in a request to be recused from this because of the conflict of interest. So I'm going to turn it over this time to my vice chair to run the meeting.
Okay. Commissioner Waller has recused himself. So item 3B, have a public hearing and action for annexation and zoning. Public hearing, consideration, and action for the city of Kerrville to annex into its incorporated limits, and a recommendation for a zoning classification of R1 single-family residential district for an approximately 194-acre tract of land generally located on the south side of State Highway 27 between Oakway Street and Split Rock Road. Trent, could you give us an update on?
Yes, sir. Today, item 3B, as you just mentioned, is the zoning designation for the approximate address 337 Split Rock Road. Staff is recommending that the R1 single-family residential district zoning be applied to this piece of property. This piece of property is in the process of being annexed by the city. The city of Kerrville has initiated the process to annex into its corporate limits the aforementioned property. We did mail out 37 notices to all property owners within 200 feet. 0 came back in written form, 0 came back in favor, 0 in opposition. We have not heard anything back from anyone via phone call as well. The subject property is relatively flat. It gradually slopes from the north end of the property towards the middle, slants a little bit more towards the river, then kind of brings back up. It's minimal slope on this subject property. The land uses surrounding the subject property are, to the north, a single-family well-established single-family residential neighborhood, and to the south, there's also a single-family residential neighborhood established. Down the street, further down the road, there are various uses such as the school, such as the high school, with their playing fields that are close by. The property land use designation per the city's comprehensive plan is low-density residential. The proposed R1-based zoning district is consistent with the plan's future land use map. The city of Kerrville's comprehensive plan has designated this portion of Highway 27 to be geared towards detached single-family residential uses not to exceed a density of 1 to 5 units per acre. The subject tract is being developed as a sand and gravel pit upon annexation and zoning. Any pre-existing sand and gravel operations that have been verified at the time of annexation will be considered legal non-conforming uses and subject to Article 11-1-16 of the city zoning ordinance. Staff has found no evidence of likely adverse impacts on neighboring lands in relation to the zoning designation proposal. The proposed zoning district is consistent with the comprehensive plan and surrounding land uses. The properties located to the north and south are well-established single-family residential neighborhoods. The proposed zoning district will allow for future development of the subject property to remain cohesive to the existing land use pattern of the immediate area, resulting in minimal impact. City Council did pass a motion to direct the mayor and staff to immediately initiate the annexation process as presented and to begin discussions with various parties on January 12, 2016. As part of this process, we are required to bring a zoning recommendation to Planning and Zoning Commission. In Article 11-14 of the City of Kerrville Zoning Code, it states the Planning and Zoning Commission shall hold a hearing on all proposed annexations and shall at the same time hold a hearing upon the zoning that is to be given to the tract to be annexed and make a recommendation to the City Council for the zoning of the property upon annexation consistent with the purposes of the zoning code and the comprehensive plan. Concurrently with the adoption of the annexation ordinance, the City Council shall adopt the zoning of the area of tract being annexed. Number 1, determination of vested rights. Any person claiming property interest in land located within the newly annexed area may apply to the city planner for determination of the vested rights. If any if any, to continue the development-related activities or uses initiated prior to annexation. The city's determination shall be limited to a continuation of the development rights previously established under state law. The city planner's written determination shall be final unless his or her determination is duly appealed by the applicant to the Planning and Zoning Commission in accordance with Article 11-1-23, Appeals to Administrative Decisions. Number 2, continuance of development activity within a newly annexed area. No person relying on a claim of vested rights shall continue any development activity that requires a certificate of occupancy without first applying for and obtaining a building permit. Thank you.
Thank you, Trent. Before I open this public hearing, I want to just take a second and remind the commissioners that we are not here to discuss the merits of the annexation itself. We are only here to discuss what zoning of this property should be if it is annexed. That same comment goes to the audience as well. If there are concerns about whether or not this property should be annexed, those concerns should be directed towards City Council. Those are not concerns that are going to be reviewed at this meeting. We are only concerned with the zoning of that property if it is annexed. At 5:02, I will open the public hearing. Please state your name and address.
Yes, hi, I'm Chance Allen, 18715 Desert Flower, San Antonio, Texas, and I'm representing Martin Marietta today. And the first thing I'd like to say is that, this group has been working extremely hard with the surrounding community. We have been working very hard with the county. We've also been working very hard with the city in order to have a win-win situation with this property. And so the first thing I'd like to ask is that because we've made so much progress and things are moving in the right direction, we'd like to table this issue at least 60 to 90 days to give us time to continue those discussions to find a win-win situation. And if that request isn't something that we can get, or if you're not able to give us that extension of time, the one thing I'd like to remind everyone is that we purchased this property with the sole intent to mine the property. We have documentation and contracts at the time of purchase more than a year ago to mine this property. We began mining this property and utilizing the property for mining sand and gravel long before there was a vote to try to annex this property. Okay, so as far as the rights and protecting our constitutional rights, both in Texas and for the United States Constitution, we feel like this, basically provides a lot of risk to our ability to mine the property, to come back and zone it, to control our property rights. And that's unfair. That's unfair. We've done nothing wrong. We've been operating this site in a manner that follows the law. And so I just want it to be known that it will create somewhat of a mess to go into a property, and even in Kerrville's bylaws it says, hey, we will not change the use of the property through the use of zoning. But if that's true, then you have a property that's been mining that will be continued to be mined, and then we're going to try to zone it residential. And I don't understand how that works, and I think the courts would have the same opinion of that. So I just want to make it clear our position is that we'd like to find a win-win. We want to work with the city. We want to work with the county. We want to continue to find ways to have sustainability. But at the same token, if our rights are violated, then we want to fight for those rights, to keep our property rights for the intended use and the continued use of the property the way it is. Thank you.
Thank you, Mr. Allen. Was there anybody else who would like to speak at the public hearing?
Tom Moser, 240 Ranch House Road. Question, why is this being brought up now to zone this?
I believe, correct me if I'm wrong, Trent, it is part of the process of the annexation process that
Right, yes,
we
sir.
have to determine the zoning
Yes, sir.
classification as part of the annexation process.
Yes, sir.
So it's got to be part of the annexation. That's the answer.
Yes.
So the zoning comes before the annexation.
Well, the Yeah, in order to complete the annexation, a determination of what the zoning would be has to be made by this commission.
Okay.
Any other speakers for the public hearing?
Is George Brody, 1616 Glen Road, as kind of as a follow-up to his, understanding that you have to do some zoning, why are we choosing residential if the known owner of it is clearly not? Why do we choose that?
I'm not sure. I would have to direct that question to the city planner.
The current comprehensive plan calls for that area to be low-density, single-family residential, so to be consistent with the low-density, to be consistent with the comprehensive plan, the R1 zoning district is the zoning district we would apply to that area. We never received anything for a petition to change the zoning. That is always in the owner of the property always has that right to petition to change the zoning.
So after this is passed and if it was annexed, they would then have the right to petition to change it? Is that
If
what you
they
mean?
so choose, so yes.
Okay.
There's no zoning, it's still in UTJ. So currently the property isn't
Currently probably isn't,
zoning.
right.
Yeah, the zoning wouldn't go into effect until annexation was completed. And then at that point, the property owner can request a zoning change.
Okay, to be clear then, it is somewhat adversarial for us to be zoning it residential, correct? I mean, you don't have to answer that. I just think it's somewhat adversarial. That's all. All right, thanks.
Okay. Any other speakers for the public hearing?
Right, question. Isn't residential the default when property is annexed? The default zoning?
Generally, in most cities, when they annex a piece of property, the default is single-family residential. In this case, since the comprehensive plan does state low-density residential, that is the zoning that staff has gone with due to the comprehensive plan and remaining consistency.
If you're in negotiations with Martin Marietta, what's wrong with delaying this 60, 30 days, 90 days? Is there some reason? You need this zoning before you can do an annexation? Is that what you need?
The annexation process and the zoning process go hand in hand.
But you sound like we have to do one before we do the other.
Well, it needs a zoning designation
In order
when
to
the
be
property is
annexed.
annexed. Right, in order to be annexed.
But if it defaults,
If the annexation for some reason is not approved, the zoning will not be approved as well. It will not,
Okay,
will
it
not be
was,
adopted.
Well, whatever happens under that article 11.116, that's a grandfather clause. Am I misunderstanding that?
Right, they'll have certain vested rights. You're right, sir.
what was what is the current, you said it's low density residential now?
it's not zoned.
Or, it's, well,
It's outside the
in
city.
the
Is it-
master plan, okay, when was that established?
Comprehensive plan, yeah.
The comprehensive plan was originally adopted in 2001.
Okay, I was on the master plan update committee, update review 5 or 6 years ago.
In 2008, when that area was not changed in the update as well.
It was not changed
No,
then?
sir. The update in 2008 maintained that low density residential for this area.
So this, historically, it's a low density residential plan.
Yes, for our future land use, for our comprehensive plan has always stated this is low density residential in our comprehensive plan.
Has there been any other developments that are not low density residential in this area?
I need to go back. There's the single family residential to the north, to the south. I need to look at everywhere in this area that's.
Fox Tank, and you brought up the airport, and, you know, we have industrial development actually right there by the airport, and the list goes on. I mean, that was actually in the case we just heard prior to this one. I mean, these are within a mile from one another, and so the other question.
Not to be rude, is there any way you could talk in the microphone so we could have it all on record? I apologize.
No, no problem. So my original question was just, have there been any other developments in this similar area that are outside of the low-density housing? And I already know the answer to that, at least since 2001, if that's the date we're referring to, and there's been a lot of development in this area. I think the other thing we ought to consider is there is, zoning associated with mining. And if this is the use of the property currently, why isn't that being looked at in terms of an opportunity to get the zoning right for the use of the property? That would be my question.
Fred, it makes no sense to me, knowing that they own the property, it's gonna be mined, for us to come in there and put residential zoning on it?
Is it being mined as we speak?
I mean, that doesn't compute in my book. I don't understand the reasoning or rationale for doing that. That's just like it's picking a fight.
What's the purpose of annexing?
You need to direct that question to the mayor and the council, who voted to start this process.
Should I close the public hearing? Is there anybody else that would like to speak at the public hearing?
I believe you've already closed the public hearing. Was the public hearing closed?
No.
No, it isn't closed.
I apologize. I thought it already was closed. I apologize.
I'm gonna go ahead and close public hearing at 5:14. I agree with Commissioner Morgan that the R1 designation poses a conflict with what we're currently presented with. At the same time, if that wasn't the case, if the city was just going to annex this property, we have low density residential on one side and low residential on the other, a high school across the road. Some of that does make sense. Having low density residential right up that close to a highway that gets that much traffic is concerning to me. But I do agree with the current situation presented to us that R1 zoning doesn't seem appropriate. Are there other options out there that we can consider?
Well, I think we have one option. We can delay making a decision today. I would make a motion that we delay the zoning determination for 60 days.
I second.
Before we carry that through, I have a question. If zoning is delayed, does that delay the whole process as well?
It's probably one clarification we need to investigate a little bit more, but there is not an automatic zoning provision. So when the property annexation proceeds on, there's got to be a hearing and a recommendation from P&Z in consideration of the zoning by the city council. So at this point, the annexation process has to continue. We're not zoning this prior to or early. This is really running concurrently to the annexation process. The zoning ordinance contemplates when you have legal non-conforming uses that are existing when they're annexed and zoned. So the comprehensive plan is low-density residential. The R1 district is the district that we have on the books today that addresses that land use compatibility. There isn't a straight zoning district we have right now that allows by right or by conditional use permit mining in the zoning code today. So there's some additional amendments to the zoning code itself that P&Z ultimately will need to consider should this property be annexed, or maybe you want to consider that irrespective of this particular case. There is some value from the city's perspective in terms of annexing and have this property in and a non-conforming use with the R1 district. It doesn't prevent the owner from being able to operate according to the uses and the rights they have established today. But what it does mean is that if there's any increase or modification to the nonconformity, then that would have to be accommodated within the context of our zoning code. What our zoning code says is that where you have a legal nonconforming use and you want to modify or expand that use, there is a conditional use process that applies to that. So any additional change or expansion, things like that, that aren't determined to be vested in that property today are things that would come back for consideration later. So with regard to what the effect is, the determination on the annexation doesn't necessarily affect the timeline or the timing on the annexation process. That's an additional consideration that City Council have to consider moving forward. So I don't know if that helps clarify that question at all.
Okay. Thank you, Todd. Yeah. I agree. The common sense, to me, understands that the current owner will be able to continue his use regardless what we zone it now.
That's right.
And if that's the case, at some point, it could revert back to that R1 zoning, at which point it doesn't make sense to have it zoned as R1 if work has been done on this piece of property for 5 years or 10 years or something like that. I don't think we could look at this, or at least I couldn't look at it responsibly and not consider what the condition of that property is going to be over time. That's why I feel that the R1 zoning doesn't really seem to be appropriate given the certain circumstances. But I'm just one voice.
Well, it seems to me that most of the time, whenever we have a zoning request, it comes from the landowner, or the new buyer wants to come in and ask for a zoning change because they're going to do something with that particular site.
Right.
What we have here is the city wants to move in a certain direction, and the default is to R1, versus the landowner wants to move in a certain direction. I think those two parties need to get together and figure out what they want before we make a decision. I don't see making a zoning decision without the application of the owner.
I just my case, city attorney, and I hate to speak in these matters, particularly if Martin Marietta is not represented here by council. They are represented by council. We've received a letter from their council out of Atlanta, Georgia. I want to be clear. They could have requested a zoning change. You alluded to this. An owner, developer of a proposed piece of property, they could have done this for the last, since certainly January when we were considering this issue. We've been trying to meet with them. I disagree with the characterization of working very hard to get together. We've worked very hard to get together the last 2 or 3 weeks. We haven't been able to do that. My point in getting up here, though, is you can't negotiate zoning. Zoning cannot be negotiated. It's called contractual zoning, and that's illegal. Zoning is a legislative manner, which doesn't mean that we don't listen to the landowner, we don't listen to the developer, we don't take into account what they want to do out there. But we can't negotiate with them, okay? There's some value, I don't know what they're thinking, I haven't talked to them. There is some value for landowners and developers to maintain a piece of property as a legal non-conforming use, okay? That might be their issue, that might be their goal all along. There's value, obviously, in getting it zoned as for mining and gravel production. I don't know. I can't speak to that. I haven't spoken to them. I haven't spoken to their attorney. But that's kind of where we are. I'll reiterate, council has moved that the mayor and staff work with Martin Marietta. We've sent them a letter back in January and have offered to meet time and time again with them and haven't been able to do so. We're more than willing to meet. But y'all's role here today, your scope here today, is to come up with a recommendation for zoning. And that's it. I mean, in the code, in the zoning code, it says you shall. Nothing with respect to, you have to hold a public hearing on annexation, but you also hold a public hearing on zoning, and then that's when you make the recommendation. So, and this isn't some, thing that staff has pulled out. This has been, at least since 2001, has been on the books, so to speak, as a comp plan for single-family residential. So this isn't something that Trent's just going along with because it makes sense in his planning world. He has to do that. State law requires that we follow our comp plan. And so all that being said, I think that you all, my advice is to leave the zoning as is, single-family residential, move the process along. It'll be read on first and second reading in April if council decides to continue moving along. And the property owner at any time can come in and request, if they choose to do so, a zoning change.
Mike,
Yes, sir.
I think the situation was very well stated at a council meeting a few meetings ago when Stephen Fine said, it appears that the city is being reactive rather than proactive. This should have been done prior to something like this happening. That property has been available a good while, I understand. Zoning, maybe it done then, would have prevented this. Why, is our only option to say yes to R1 or no to R1, or can we say, well, maybe not R1, but maybe some other designation?
Or can we delay, Mike? I guess is the other question is, can we delay this for a period of time?
I don't believe under the zoning code you can delay. It
Okay.
talks about you all shall make a recommendation of zoning to council. And that zoning has to be part and parcel consistent with the comp plan. We've heard from, you've heard some additional comments from the owner. Again, we're willing to speak, but willing to talk to them. With respect to, they probably have some questions on annexation. They probably have some insight into zoning. Mr. Morgan, you bring up a great point. To me, that's a policy decision, and I respect council members' Fine's comments. But all I know is that there's a motion from the mayor and staff to move forward with annexation, and zoning is a part of that, and that's what we're doing. This will be scheduled for another public hearing next Tuesday at council for the second public hearing, and then 2 ordinance readings in April. So we've got a month and a half still of meetings and actions that council must take. And at any point in time, council can decide to, hey, let's tap the brakes and maybe consider and meet with the owner.
But again, my question is, our choice is either yes R1 or no R1. We cannot make any other
I think
designation.
I don't want to belabor the point. I think you are a bit constrained with your actions.
Okay.
But I think you all can also make a recommendation for council to consider more appropriate zoning, whatever in accordance with the current use. I mean, obviously, Martin Marietta has owned this for the last year. They're involved in some form of gravel operation and mining operations now. We don't know exactly, but I mean, we're not here. The city is not here to annex them and zone them, and then tell them tomorrow that they're no longer allowed to do what they're doing. I mean, that's not our intent. And I agree, there's constitutional, both state and U.S. constitutional rights that they want, and I'm certainly not interested in violating any of those.
Okay, so it sounds like a delay is off the table, but I don't feel that an R1 zoning is appropriate for this property.
Can I make a motion?
You bet.
I'd like to make a motion that we decline the R1 and send council our thoughts that maybe they should consider a different designation in light of the current use of the property.
We have a motion. Do I hear a second?
I'll second that.
We have a motion and a second. All in favor, raise your right hand. Aye. Motion passes 4-0. Okay. Item 5. On the agenda is staff reports.
There's nothing to report today.
Nothing to report.
Yes, sir.
Okay. Do I hear a motion for adjournment?
So moved.
Second?
Second? All in favor? Meeting is adjourned.